there are some other things that they can do according to the statutes to really cure any of the other problems. All right, so let's think about it this way. If the court decides, all right, listen, we understand your arguments. We know we set a $2 million bond, but we're going to end up, make your arguments. We're going to release him, but we have to do these three things. We have to make sure he shows up to court. We have to make sure he's not a danger to the community. He's not a flight risk. And we have to make sure he doesn't intimidate witnesses. How can we do that? Is there anything that the law allows us to do so that Kyle can get out of custody over these next 2-3 years while the case is pending so that he can live his life and continue to develop as a young man? Well, fortunately, the Wisconsin statutes do provide some alternatives. They give us some options that we can use to craft a good release schedule. So here's what that statute looks like. So it's 969.03. This again comes from Wisconsin. Here's what it says. A defendant charged with a felony may be released by the judge without bail if a couple things can happen, right? They need to ensure that the person appears for trial, and they can impose these conditions to make sure that that happens. So a couple things that they can do. They can place the person in the custody of a designated person or organization. So they could give basically custody of Kyle to somebody, to his mom, to his parents, to an organization for young men, to a school, a charter school. So, there has to be some organization in the United States who is willing to step in and say, look, we're gonna vouch for this kid. We're gonna make sure that this young man, make sure that he is in our care and that we're not going to allow him to do anything that's going to impede the goals of the court. They could easily do that. They could also place restrictions on the travel, the association of the place of abode of the defendant during this time. And so here what we're talking about, well, Kyle's place of address where he lives is in Illinois, in Antioch, and he could easily, move. I think it's not far from Kenosha. He could move over to Kenosha. He could put permanent residence there, or a place in Wisconsin, or a place right on the border, or they could craft some sort of option for him and say, look, we're going to let you out of custody, but you've got to do this, this, and this. You got to stay here and do this and report home and do all of those things, which would be significantly better than sitting in custody. They can also prohibit the defendant from possessing any dangerous weapons. So that is a no-brainer, right? Let him out of custody, release him on his own recognizance, and say, you can't touch a firearm. If you touch a firearm, if you're near a firearm, if you're in the same building as a firearm, if you go to a gun store, you're going back into custody. Okay? Don't get near it. That would be a good way to cure. They could release him and say, just don't touch a gun. If you do, you're going back in. I think that would be pretty reasonable as well. They could also require, of course, we've talked about this, the execution of an appearance bond, and they can do other things reasonably necessary to assure the appearance as required and protect the members of the community and prevent the intimidation of witnesses and return to custody at the specified hours. So how do you do this? There are many ways you can do this. There's no reason he has to sit in custody for 2 years. You can do this with house arrest, right? You can just send him home and say you're not allowed to leave home. How do they monitor that? Well, they'll do it with ankle monitoring. They'll put ankle bracelets on. They also have devices that you can install in your home, and you can connect them to a landline. So I don't even have a landline at my house. I have a cell phone. That's the only thing that I use. But there's equipment that you can buy. You put it in your home. You connect it to a landline so they know you're there, and they call you every now and then. You got to check in, make sure you're there. They've got a video conferencing and all sorts of things that they can do to protect that balance. Right now, there are many people who are probably watching this saying, "Yeah, but Kyle's innocent. What the heck are we doing? Why are we going to not allow him to have a gun or allow him to go do certain things? The guy is innocent," which I can empathize with that. But the court has to balance these things, right? The court is going to be saying, well, technically there are 2 people dead, another one shot, and this guy, we don't know much about him, so he's a danger to the community. So they have to balance it. They have to protect the community, make sure he's showing up to court, and protect his freedoms, protect his liberty, make sure that this kid is getting the proper representation and the proper arguments are being made on his behalf, I think is where I'm going with that. I think it's very important. So eventually this is going to become ripe. We're talking about it a little bit prematurely right now because Kyle is still in Illinois and he's going to be going back to Wisconsin soon, presumably after the extradition hearing, but this could take months. When he does get back over to Wisconsin, they're going to have that $2 million bond and it's going to need to be addressed. This is something that we do pretty regularly at our firm. If somebody comes to our office and they're in custody, we file what's called a motion to modify their release conditions all the time. I mean, it's a very common type of thing. The judge knows about the case just on some of the the basic factors that were available at the very outset of when everything started. But when we start working on a case, we can start to humanize somebody and start to say, okay, yeah, he was charged with intentional murder, but here's the story, right? He's 17 years old. He's never been in trouble before. A couple speeding tickets. He's a lifeguard. He's got a loving family. He's got, not to mention all of the legal defenses in his case. But let's just talk about the human side of this case. And so you make those claims, you go back to the court and you say, look, here's our plan. If you release this individual, here's why it's important. We need him to work on his own defense. We need to do interviews with him. He's going to need to, sit with us and analyze exhibits and do all of this stuff. It's a better environment for his defense to keep him out of custody. Whereas somebody who's in custody, the attorney's going down there all the time and they've got to, it's just a big ordeal. So it's a lot easier for his defense. It's a lot easier for him personally, right? He can go back to school. He can get a job. He can show the world that he's actually not a murderer. He's just a young man who's in a bad situation. And so this is super important. And in addition to that, it's just right. It's the right thing to do for his mental health, his mental well-being. To have him sit in custody for the next 2 years is going to be very detrimental to his his whole life is changed, obviously, as a result of this, but keeping him in custody without human contact, especially during these very sort of formative years of a young man's life, that is going to be a tall order for the next 2 years.